release the maximum number of participants. Hello all, my name is Shahrukh Kumar. I'm from the Managing Committee of Kovise Foundation Conflict Resolution International. On behalf of the Managing Committee, I extend a warm welcome to all the attendees who have joined us from different parts of the world. I'll be the host for the session. The session will be moderated by my colleague, Mr. G.S.Suvethan. We have with us Mr. Aaron Dowling-Hussey, who will be the speaker for the day. A quick brief through the housekeeping rules. So today's session will be a 1 hour session on the topic how to become an arbitration practitioner. So the last 15 minutes will be reserved for question and answers. Participants can now and then post their questions in the Q&A box. We kindly request the attendees to refrain from posting your questions in the chat box. If you have any audio or video connectivity issues, you can contact us through the chat box. We'll resolve it. And moving on to a quick brief about the institution KFCRI. So Kovise Foundation Conflict Resolution International is the first of its kind institution. We are an ADR institution as well as an accrediting body. So as an ADR institution, we have our own rules like KFCRI arbitration rules, mediation rules, conciliation rules, and we have the tribunal secretary rules. Apart from this, we provide accreditations to practitioners in the field of arbitration, mediation, conciliation, and tribunal secretary. One of the prime motives of KFCRI is to promote the practice of alternative dispute resolution mechanisms and to create awareness about ADR. Towards this initiative, KFCRI, under the guidance of our project advisor, Mr.V.Inbavijayan, we have started the KFCRI webinar series. So once again, I extend a warm welcome to all the attendees who have joined the second session of the KFCRI webinar series. Now I request the project advisor, Mr. V.Inbavijayan, to give a few words about this.
Welcome to all. I'm happy to introduce Mr. Aaron Dowling-Hussey, who is also an advisory board member of KFCRI. At this juncture, it is very interesting to hear from him regarding the topic how to become an arbitration practitioner. As KFCRI's main objective is to bring many practitioners into arbitration, this particular session on arbitration practitioners and how to become, I think would be really interesting to hear from Mr. Aaron. To say a few words about Aaron, Aaron is a barrister, adjudicator, arbitrator and mediator based in Dublin, and he's also admitted in Belfast, North Ireland, London, as well as Falkland Islands, including the Astana International Financial Center courts based out of Kazakhstan. Interestingly, Aaron is presiding a very interesting arbitration and an ongoing arbitration of DIFC LCIA, which is an arbitration institution based out of Dublin's as a seat. And to add on, Aaron is listed as an arbitrator in Global Arbitration Review, particularly in their arbitration research tool. Very interesting thing about Aaron is he is a properly accredited arbitrator when it comes to the academic qualification. He has 2 diplomas, one diploma in arbitration, which he got it from Dublin, and another diploma in international commercial arbitration, which he got it from Kebli. Interestingly, these 2 diploma led him to ultimately become a member of the Board of Trustees of Chartered Institute of Arbitrator. And now we have him as one of the advisory board member of KFCRI, which is a pioneer in training arbitration practitioners along with mediation and other tribunal secretary. Now I request Suvethan to take forward.
Thank you, Mr. Inbavijayan, and thank you, Mr. Shahrukh Kumar. Mr. Aaron, I would like to first introduce you to the audience, the attendees. We received around 400 registrations with a varied background. We have engineers, we have advocates, we have students, we have barristers, we have professors and whatnot. So the question or the theme of this webinar, how to become an arbitration practitioner, must, in my opinion, be answered to all of them. So I would like to first start off this entire session by asking you the first question, which is, who can be defined as arbitration practitioners and who are the stakeholders of arbitration practice?
Okay, thank you. And I've got the webinar chat box open, so I will be glancing at it from time to time. So just before I get into the substantive points that we're going through, somebody's raising a query about previous PowerPoints. And somebody says that the webinar is not currently working on Facebook. So I'll move on past that. But while we're on air, if you do use the chat box, I may see it, I may not, depending on where we get to with the later remarks. So an arbitration practitioner is rarely a full-time practitioner in arbitration. So in some instances, there are people who might like to be a full-time arbitration practitioner, but the nature of the marketplace is that that's not possible for them. And conversely, those people who are in a position to be a full-time arbitration practitioner, often they choose not to do that. They place a value on continuing to engage in their primary original profession. And they also see an overlap between arbitration and some of the other dispute resolution processes. So they find it helpful to continue to do some work as an architect or an engineer or a lawyer. And they find it helpful to not only be an arbitrator, but also to be a mediator. Now, of course, an arbitration practitioner, as far as I'm concerned, includes a party representative in arbitrations. And again, there would be few solicitors and barristers who only appear in arbitrations. So normally, you'll find wherever you are, there's no exact agreement on definitions that are used. And because of the international nature of arbitration and alternate dispute resolution, that there's differences in culture and approach in some countries. There's many similarities, but there's differences in the jargon and phraseology used between countries. So as a brief example on that point, without spending too much time on it, you would often hear people talk about talk about mediation and conciliation interchangeably, as if they were the same processes. In my own primary jurisdiction in Dublin, conciliation has a very specific meaning in relation to construction disputes. So moving past that issue, and I can come back to it if anybody wants me to at a later point, moving on to the issue of stakeholders. Quite simply, a stakeholder at its most basic level is a person or organization or entity who has an interest in a particular area. So when you're talking about stakeholders in international arbitration, you're talking about, in no particular order, the institutional bodies active in international arbitration, like the ICC, the LCIA, the CIARB. And I should just say, I'm speaking in a personal capacity. I do factually happen to be a member of the Board of Trustees of the Chartered Institute of Arbitrators, but I'm speaking purely in a personal capacity. And in some instances, over the course of an hour, where I'm asked to give an example about some specific point, I will often refer to the CIARB, but that's mainly because I'm more familiar, say, with the student membership scheme they offer than, say, some of the other comparable schemes. It's not to attempt to suggest that they are the only options for people. So stakeholders, the institutional bodies, practitioners, those entities, universities, and so on, organizations like KFCRI who are organizing training and courses and seminars. So stakeholders quite literally are, you know, those who have an interest in an area.
No, thank you, sir. So in this wide scope, my next question would be, in your varied experience, what are the roles you got an opportunity to play as an arbitration practitioner?
Okay, purely on the arbitration side, I have acted as a tribunal secretary. I have acted as a sole member of a tribunal, an arbitrator sitting on my own. I have acted as a member of a 3-person tribunal, as a co-arbitrator or a wing arbitrator, and I've acted as the chairman of a tribunal. I have acted as a counsel in arbitrations, a party representative advising whoever brought or is defending the arbitration. And I've acted in court applications that arise before, during, or after domain arbitration. And I've acted as a legal advisor to non-legally qualified arbitrators. So in certain instances, with the permission of the parties, an engineer or an architect can say, well, look, this is a very complex or niche area of law, and I think in this instance, I'd like you to agree to me getting outside legal advice. So those are the roles that I personally have played.
Thank you, sir. Thank you. That is really humbling. Before we dive on into the main theme of the webinar, I would like to ask more of a general question for the benefit of the audience. What in this field of arbitration, which is also a field of law, what do you think are the sources for one to develop their knowledge in? So where can one person go to learn more about arbitration before we go on to the main topic?
Okay, there are a range of courses around the world, and I presume I can make presumptions about where many of the people who are participating are from, but I'd be reluctant to do that because I might get it wrong. And so, I mean, if anybody has any very specific, discrete queries about courses and so on that aren't covered by my remarks, I'm happy for anybody to email me directly, and I'll put my email in the webinar chat now. And so I don't want to spend 10 minutes talking about courses in Stockholm or Geneva or London, you know, where everybody's individual concerns and focuses will vary. And whilst I can offer an opinion on courses anywhere, out of all the panelists on screen today, I'm probably not the person to ask about the merits of the course in India. You know, I'm happy to try and offer an opinion, but that's maybe not one to be directed to me, just because I wouldn't quite have the same knowledge as my colleagues on screen would have on that issue. So I've put my email there, and while I'm doing that, somebody says that a video is lagging. That maybe was a few minutes ago, and somebody has raised a query about how engineers can gain legal knowledge. Well, the answer to that won't specifically just be in relation to engineers. It will apply to anybody who's a quantity surveyor, an architect, or whatever other primary profession they have, which isn't legally related. There's a range of courses. and there's a range of approaches into arbitration. A certain number of people will start off studying law, and they will qualify as a lawyer, and at undergraduate level or postgraduate level, they will have studied arbitration or ADR. They will have developed an interest in it, and they will look to focus their legal career in a way where they can get into ADR. Whereas some people find out that arbitration is interesting or relevant to them later on, while they've been working for a number of years. And in that instance, it's possible to do a number of postgraduate diplomas or master's degrees. Often you can do those courses online, so it doesn't necessarily mean that you have to physically attend anywhere or take a year off work. Again, I am only mentioning it because I'm a lecturer for them. I'm not trying to ram it down anybody's throat. Sorry, not the most delicate phrase, apologies for that, but I mean, I'm a lecturer for Robert Gordon University in Scotland. The LLM is in construction and arbitration law and is completely online based. I've never been to Aberdeen. I've been lecturing for 3 years. So if you're taking the course part-time for 2 years, you might want to go to Aberdeen for other reasons, but you don't have to go there purely because you're a student on the course. So it obviously depends on people's circumstances. Range of diplomas, LLMs, often they can be done part-time. In some instances, people will choose to take a year off work and do a full-time course. There's various high-end courses in Geneva and Stockholm, Pepperdine University in America, and obviously the cost of foregoing your year's salary, going abroad, rental accommodation, university fees is not inconsiderable. And obviously, again, the normal academic calendar due to the COVID-19 situation is not operating in the same way. So I mean, the issue there, the way of addressing that is if you're minded to do an online course anyway, it's maybe the easier way to go while there's a degree of uncertainty in the world.
Thank you, Aaron. So you've actually moved on to the next question, which I really wanted to ask. So as I said, we have a varied background for the attendees. So there are people who are just studying law right now, and they are in the initial stages of their arbitration career. Or some people are right now in a different field and they want a mid-career change into arbitration. Or people are in their retirement and would like to be a part of this field of arbitration. So with reference to these three different differences, how do you think each one should enter into the field of arbitration?
If I can take the last age group first, if that's okay. So if you look at the various websites and directories and journals around the world who would attempt to rank arbitrators, one of the top 3 or 4 arbitrators in the world at the moment is 85, or give or take. So it is it's a career that is usually a secondary career for most people. So I go back 10 or 15 minutes to my initial remarks. Many people won't ever be in a position to do it on a full-time basis. and others who can do it on a full-time basis would choose not to. But possibly when somebody's at the age of 65 or 70, without me being rude, they won't want to work at the pace that they would have wanted to work when they were 35. So when somebody is retired, working in arbitration as and when it arises, as suits them, might be an issue. And there's certainly opportunities for people who are 65, 70, or in and around that age group. I mean, one of the issues is, how do you get work in arbitration? You need to capture and maintain the confidence of the parties. So on a very simplistic level, I'm reminded of a youngish barrister who got more work than his peer group was getting. And one of the suggestions was because his hair turned white at an earlier age. You know, so there's a comfort to people who are involved in a dispute when the person sitting in front of them isn't baby-faced, you know. So now there's a range of specialisms and areas where you can work as an arbitrator. So in some instances, if somebody's had a career in a particular field, they can then maybe transition into getting involved in dispute resolution. So for instance, if somebody spent 30, 35, 40 years working as an architect or engineer, on retirement, it may be that they can relatively quickly do a course in arbitration and join some membership organizations where they have a chance to meet other people in the field and sort of staff in that way. So some of the arbitral institutions offer expedited courses that can be done in a week, or in some instances 2 or 3 days. So I should point out that I can obviously only comment about my background and experience, and in some instances a colleague who was here with me would offer a different point of view. So, you know, there's not always a sole answer or a singular answer, an absolutely right way of doing this. So in my case, there were remarks 20, 25 minutes ago that I had taken various courses and so on. One of the courses I took was a diploma in international commercial arbitration, organized by the Chartered Institute of Arbitrators, it's an intensive 9-day course. So over the years, it has been run in various venues, but it's always been run in Oxford in England. So I've sort of lost track at various times. They've run it in, I think they've run it in Hong Kong or somewhere a few times. They've run it in America, but that's one fast track course that in some instances will be suitable to people. So going from the oldest to the youngest, I think as hard as it is, it's important to be patient when you're starting off your career. I do meet some younger colleagues who think that they can sort of in a relatively short time wake up one day and they will just be sitting as an arbitrator every day of the week. In my experience, that's most unlikely. So for younger practitioners on the legal side, within the common law or English-Irish model, I mean, you'd either be a solicitor or a barrister, and you need to normally develop other areas of work that you will be focused in. And again, I mean, one of the sort of old stories I've heard, along with the prematurely white-haired colleague who suddenly got a bit more work, is I've heard lots of people who commenced their legal practice and wanted to be commercial lawyers, and then because of the nature of work that they received, they followed that work, so to speak, and they ended up being a criminal lawyer instead of a commercial lawyer, or vice versa. So I mean, I'd suggest on the younger side, keeping an open mind and following the work. Follow the work you do, and if you like it, follow where that goes. And there is that necessity to have a wider hinterland when you're younger, and when you're younger, it's more realistic to be a party representative, a solicitor, barrister in an arbitration. It's more realistic to be a tribunal secretary, and basically it's not really very original of me. It's about getting out there, meeting people, pursuing a range of activities, doing a little bit of teaching, lecturing, training, writing where you can do. And also, ADR does overlap. The same people are mediators and arbitrators, and therefore try and explore the whole gamut of the ADR options. So I see one of the questions, what is the part-time course available to become an arbitrator? That there are part-time course, there are a range of courses. I referred to the Robert Gordon University LLM in construction and arbitration, which can be done online, which, as I said, might be advantageous for some people at the moment with the degree of uncertainty we have in the world. And that course exempts you from the prerequisites to join the CIARB. So again, that's something that some people find helpful. For mid-tier professionals, people in the middle of their career, they have the advantage over their younger colleagues in that they possibly can be more focused. They will maybe have had some degree of involvement, or will have observed mediations or arbitrations or statutory construction adjudications at a distance. And so when you're at the middle stage of your career, there's a greater logic than when you're at the start to say, well, look, I want to focus my endeavors here. I don't really want to go to seminars about that particular process. I don't really want to do a short course in that particular process. I have a view of the world at 35 or 40 that I mightn't have had at 25, and I want to take a more focused approach. So in some instances, the fact that you've got that greater experience of life can be helpful. Okay, somebody is worried that we're going to carry on for another 60 minutes. Not as far as I know.
Another 30 minutes maximum. There's this interesting question which popped up. I would really like you to answer if you would need. How can a young legal practitioner secure an arbitral reference? And how did you secure your first appointment as an arbitrator?
My first appointment was an appointment in a comparatively low value dispute where the chairman of the Chartered Institute of Arbitrators in Dublin appointed me. So possibly gonna get this wrong. You're talking maybe 14 years ago, I think. So in some instances, you can be appointed on the consent of the parties, and the parties obviously would have to know you and form an opinion that you can be relied upon to take charge of the arbitration. In other instances, the parties have placed the power of appointment in the hands of somebody else, the chairman of a bar council or the president of a law society or chairman of the CIR branch. So in my case, I had done some courses in the area. I had attended some branch events. I was known to the then chairman, and I got an appointment, as I say, about 14 years ago. So, sorry, somebody's saying, once you become an FCR, what's the next step in being appointed to a dispute? Okay, the earlier remarks that this isn't a promotional for an hour on the CIR stand, and I'm talking in a personal capacity. The CIR have a ladder of membership grades. You can join as an associate often quite quickly after a one-day course or so on, or in some instances they will recognize work that young lawyers have done after a few years in a range of disputes. You can ask them to deem you qualified at the associate level because you've been a lawyer for 2, 3, 4, 5 years. You've engaged in a number of ADR disputes. Above the associate level, there is the membership level, then the fellowship level, and then the highest level above that is the chartered arbitrator level. So in general, it might be very slightly out of date. The CIR have got about 16,000, 17,000 members around the world in about 140 countries. They've got something like 500 chartered arbitrators. So, can we move on to the main topic? Sorry,
Thank you, Mr. Jafar, and thank you, Mr. Aaron, for answering those questions. Now, I would like to ask you one specific question. So, in your opinion, what are the skills a person is to require to be an arbitration practitioner? Any key skills like linguistics or anything specific to that?
It's certainly an advantage to be multilingual. So there are a handful of common law lawyers from English-speaking countries who do sit as an arbitrator in France or Germany or whatever it might be. So it is, as I say, an advantage to be able to speak more than one language. There are some very obvious issues that would often be overlooked. You have to, as I said earlier, maintain the confidence of the parties. You have to have professional gravitas. You have to be able to manage the parties. So you have to be able to intellectually deal with the management of an arbitration from starting it to issuing an award. And you have to, you have to do that in a timely fashion, so there are various remarks and textbooks and so on, and in legal journals where in some particular instances people have taken quite some time to issue arbitration awards that shouldn't have taken too long, so the parties having to send 10, 15, 20 letters to the arbitrator inquiring when will the award be issued. Okay, so the colleague is asking us to deal with the main topic of how to become an arbitration practitioner. There's a sequence of steps you take to become an arbitration practitioner. So we've been going through those steps over the last half an hour. So I don't know whether some people have logged in late, and I am happy to deal with any specific questions that somebody might have missed or felt was not discussed in sufficient detail. But to become an arbitration practitioner, you need to have a background in arbitration. You need to have looked at the qualifications and membership that you wish to obtain to help you develop in that area. You need to have thought about, is this the area for you? More or less, though I didn't use the exact words, some young people starting their career thinking they want to work purely in arbitration will find that, in fact, their interests lie in mediation or not in ADR at all. So there's a sequence of issues to be dealt with here. So we've been approaching this issue thematically. So and on that related issue, like I've said already, this is just my view. Other people will give their views reflecting their background and experiences. And I will come back to anybody who flags a query to me by email.
Thank you so much, sir. So we still have about 7 minutes left, and then we'll move on to the Q&A session.
Okay.
So we would like to pose the last question for the evening. So it's more of a generic question again. So what do you think is the scope right now for arbitration practitioners from here on? So how will they be able to grow? Will there be any future developments, in your opinion, sir?
I'm continuously told the last fortnight about the world changing, and that when every country gets a handle on the COVID-19 situation, we won't be returning to normal, we'll be returning to a new normal. So I would have thought, because of the catastrophic effect economically of COVID-19, that there will be certain institutions and enterprises who will have a greater interest in resolving disputes expeditiously. So I would have thought that there has to be some increase in the volume of arbitrations, and in some cases there will be a focus on having paper-only arbitrations, or arbitrations where people don't physically meet and they're conducted by Zoom. Now, of course, classically, decision makers like to look in the whites of the eyes of the witnesses and so on, but in some instances, on a practical level, because of the size of the dispute, that greater focus on paper-based arbitrations and online arbitrations might arise on a very simplistic level, where there's a greater volume of work. The existing people doing that work in some situations won't be able to deal with that flow of work, and younger people or people retiring who want to do a few days a week or a few days a month work will have greater opportunities than they would have done 5 or 10 years ago. So now predicting the future is not something so far I've ever been especially good at, but in a very loose way, that would be what would occur to me at this moment.
Thank you, Aaron. So I guess we are running out of time with the main session, so we'll move on to the Q&A session. But right before that, I would like to sum up the entire webinar for the benefit of the attendees who joined late. So your opinion of who can be defined as an arbitration practitioner is that we cannot define it as such, that there must not be a full-time, there cannot be a full-time practitioner as such. There are majorly part-time practitioners in the field of arbitration. Apart from that, you can gain your experience as arbitration as arbitrators, as tribunal secretaries, as working in an arbitral institution, as legal counsel, and whatnot. And there are different stages in which you can come into the field of arbitration. At a young stage, you can do your graduate degree, or you can do a postgraduate degree in arbitration or ADR. And you've listed out a very nice list of institutions for us to go through also. And during our post-retirement stages, we have certain specific roles which we can play, as sitting as an arbitrator or being an expert in a particular field, and it has been quite helpful. So before that, would Mr. Inbavijayan like to say a few words?
Aaron, I'd like to hear from you. To what extent practitioners, whether they are the legal practitioners or the engineers or the chartered accountants or the company secretaries, who are really interested, to what extent their association with arbitration institutions would help? I think arbitration institutions have certain internship. They have the secretariat wherein people can get a regular employment in those arbitration institutions. And beyond that, some senior practitioners can be enlisted or empaneled in the panel of arbitrators of those arbitration institutions. To all these combinedly, to what extent we can expect that that will be helpful to be an effective arbitration practitioner?
Okay, and if I may, I just pick up a point from earlier in relation to the summary. At the very start, I should have said in most or many jurisdictions that there's no legal impediment to describing yourself as an arbitrator. So this can vary around the world. There's an old Leonardo DiCaprio movie where the character in the movie floats around the place, and he's a doctor one day and he's an airline pilot another day, and in some situations, obviously, somebody pretending to be a doctor will be prosecuted. There's no legal definition of an arbitration, of an arbitrator, excuse me. There's in many jurisdictions. Now, there's dispute clauses that the parties have agreed to, where the arbitrator has to be an engineer who can speak German or whatever it might be. So in those instances, there's a benchmark for who an arbitrator is. And more generally, you need to have the confidence of the parties. But nobody usually around the world is committing any offence if they wake up one day and say they are an arbitrator. It's not regulated in the way that it would be regulated if you were an architect or a doctor. So in relation to interaction with institutions, the institutions do, in many instances, offer various internships. So there is a LinkedIn group called Careers in Arbitration, where some of that general information is available. So the institutions allow you to meet like-minded people. So you can't sit at home thinking that unilaterally somebody is going to want to ring you up and offer you work. So at an early stage, joining and interacting with institutions is helpful. Aside from internships, some arbitration practitioners will have been a part of the secretariat of the LCIA or the DIFC, LCIA at some point in their career. So some practitioners will spend 2 or 3 years as a counsel to the HKIAC or whatever the particular institution is. So it's a different side of the fence. It wouldn't be for everybody, but some people find it helpful to have worked in the secretariat of an institution. Somebody wants the LinkedIn link to that group, and I'm gonna minimize my screen and look for that so I can.
We'll be reaching via email to all our participants and giving them the contacts. So I guess we can do it later.
Okay. Well, sorry. I can't quickly find that. So as you say, it can be emailed out to people.
Yeah, we will all the attendees with the emails and the LinkedIn profiles. So now I would really like to move on to the question and answer session right now, sir. So
sure, yeah.
Bunch of questions popped up. So for the first question, I would like to answer Mr. Abhinash Barek's question. How can young arbitration practitioners develop written advocacy, especially persuasive writing, taking into account pre-arbitration deliverables and during an ongoing arbitration? So that's the first question he posted.
Sorry, the sound went slightly at my end. I do apologize. Can you run that one past me again?
Mr. Abhinash Barek wants to know how young arbitration practitioners can develop written advocacy, especially persuasive writing and in arbitration specifically.
Okay, in relation to legal writing, where you are an existing member of an institution, and there's a range of institutions who have young member groups or student groups, that they will often have an essay competition that they will advertise. Again, I didn't naturally I didn't actually have the moment to talk about mooting, and so anybody who's an undergraduate who has the opportunity to participate in a domestic or international moot obviously would be well advised to do that. Obviously, the Viz moot is well known to people with an interest in arbitration, and they recently successfully conducted the main Viz moot in Vienna and the Viz moot in Hong Kong purely online. So so the student membership and young member group organizations that, as I say, they advertise various essay competitions and so on.
Thank you, sir. So next I would like to answer this Ananya Singh's question. Do you think qualifying bar affiliations of other jurisdictions such as UK, US, Singapore provides an added advantage to an arbitration practitioner? How important are multi-jurisdiction bar qualifications for arbitration practitioner in these days?
I think in some parts of the world where there are no great barriers to qualifying in a neighboring jurisdiction, you might find that you do that anyway. So in some instances, a group of colleagues will enjoy going to a neighboring jurisdiction to be admitted. So the bureaucracy in those instances can be filling out a form, providing a copy of your home jurisdiction qualifications and paying a fee. So where there is no great complexity to it, why not? If somebody's asking you to spend a large amount of money to qualify in a jurisdiction, and you cannot see the advantage to that after that qualification, but you think that something might arise from that additional string to your bow, I'd be slow to do that. So, I mean, I'm aware of a number of arbitration practitioners who are admitted in, 6, 8, 10 jurisdictions. I'm aware of arbitration practitioners who are only admitted in one jurisdiction. It certainly depends on the individual circumstances of the people concerned.
Thank you, sir. So there are actually quite a few questions regarding LLM. Ms. Samina Syed and Mr. Hari Krishnan both seem to have inquired on, after doing an LLM in arbitration, what would be the next step? Or is LLM in arbitration in itself required to be an efficient practitioner in arbitration?
No, there's no requirement. In many countries, there'll be very well-known arbitrators who just have the basic law degree and have been admitted as a solicitor or a barrister. So, sorry, I'm focusing, as it's a query about an LLM, I'm focusing purely on the lawyer side, with apologies to the other professions. When you are developing your career, it's a statement of intent, it's a benchmark. It may be that where somebody offering work has to choose between a couple of people, there may be that advantage that you've got a broadly similar background to somebody else, but you have that specialist LLM. It's also a networking opportunity. So it's harder to network with other colleagues who you did your LLM with if that LLM is purely online, but it's not essential, but it can be an advantage. So what you do after your LLM, well, it depends on what you were doing before your LLM. If you had been, for instance, a solicitor, you would return to being a solicitor. It may be that your LLM would allow you to change firm.
Definitely. Thank you. Next, I would like to answer Mr. Sivaraman's question. How to become an expert witness in the arbitration process?
As an expert witness, the question's a little bit open-ended in that you would have to have expertise in, I don't know, a specific area of, let's say, construction or engineering. So, I mean, it's difficult. It's difficult to deal with that now. So if the person concerned maybe might email me, I can deal with it that way. I'm just conscious that we're in the final 5 minutes, so I'll leave that one on those terms, if that's okay.
Thank you. So I found this question very interesting by Saranya PC. What kind of attitude an arbitrator should have, or maybe an arbitration practitioner should have?
Okay, and I've seen in the webinar chat box a similar question. What are the characteristics of an arbitrator? I think it's helpful to be respectful to the parties. I think it's helpful to maintain an interest, and if I want to get carried away, a love of the work. Because if you if you look at some scenarios in the case law where arbitrators have been challenged or where there's been disciplinary action against an arbitrator, the arbitrator seems to sort of have become bored or lazy with what they do. They've not kept up with continuing professional development courses suggesting how there have been changes in how certain strands of arbitration are handled and so on. So in terms of your attitude and qualities, just to keep learning, to know that you've either forgotten something or how everybody considers it should be approached has changed. So to keep learning, to learn from your last arbitration. I don't have the time to get into an example myself of what I have taken away from past arbitrations, but not with every arbitration, but often something will come up and it will allow you to be more effective in the future. And, just to be respectful to your colleagues on the tribunal and to the parties. So, I mean, the world's a complex place, as we know at the moment. Interpersonal relationships can be tricky. There are some arbitrators who are easier company for their colleagues and the parties than others. So you need to be tough. You shouldn't roll over or be malleable. You need to do the job properly. But there are some arbitrators who seem to be more awkward than they need to be. Sorry.
Thank you, sir. That was perfect, I guess. So I guess we've run out of time. I really thank you for participating in this with us. Now I'd like to hand it over to Mr. Inbavijayan for closing remarks.
Oh, thank you.
Thank you.
Aaron, it was really interesting. The very interesting takeaway from this webinar, even though it's a short presentation, what are the do's and don'ts in arbitration practice? That's what very interestingly it has been shared to the audience. And to my personal note, whatever you shared 14 years back, that was for me, it was 17 years back. The same thing, how we started in the arbitration practice. And particularly when it comes to taking how to become an arbitration practitioner, there are various points. When counsel as lawyers or young practitioners, legal practitioners, we have an option to start with as counsel. But when it comes to other professionals, the domain, even though it is shared with other professionals, the possibility or the percentage of other professionals getting into arbitration practice is very, very minimal. I think now the trend is changing. The way how, at least when we look into the actual registrants for this webinar, we can find that many were non-legal practitioners. Now, many non-legal practitioners wanted to start their career in arbitration practice. This is a good sign. I think from KFCRI, I feel to add on what the Chartered Institute of Arbitrators is doing, particularly in this region, I think KFCRI can take this very seriously and bringing all the multiple professionals into the arbitration practice. That is what we are already doing for the past 1 year under the guidance of people like you, as well as Francis and the next two speakers like Nathalie and Christopher too. All, even though we were part of Chartered Institute of Arbitrators or still Chartered Institute of Arbitrators, we want to bring the multiple professionals into the arbitration practice. And I think we, with our own experience and expertise, what we have gained, we have to take this message very seriously to all these professionals. And if this attitude and approach, particularly the characteristics of the arbitration process, I think another decade would be the decade for the area of law. The practitioners would be the area of arbitration practice, bringing in all the professionals. I think that is the takeaway from Aaron's. And very interestingly, Aaron is also admitted in various jurisdictions. Smartly, he wanted to just confine with Dublin, but very interestingly, he has reached the entire United Kingdom as well as the Astana. Astana is very interesting. The Central Asian, the actual capital of the Kazakhstan, the very large country in Central Asia. And to finally sum up from my side, it is very clear that for an arbitration practitioner or a person to become an arbitration practitioner, we should have the passion to travel. Exception is COVID-19. We have to have the passion to take all the cuisines, whatever available. And if our physique is adopting to all, exception is language. Language you can manage with all these latest technologies. I think we can really venture into the arbitration practice. That's what my final say on this. I think, Aaron, I am right?
Yeah.
Yeah, fine.
Thank you to the participants and to the organisers for the invite. I was honoured, and I hope some of it was of help. Thank you.
Thank you. On behalf of the managing committee, we extend a warm thanks and gratitude to the speaker, Mr. Aaron Dowling, and to all the attendees who have joined us to this webinar from different parts of the world. We'll be having our next session of webinar on 25th of this month. Ms. Natali Najar will be the speaker for the event. I'll be sharing the poster for the event right now.
Great. Thank you.
So we'll be reaching out to the attendees with the registration link for this webinar very shortly. Once again, we extend a warm thanks and gratitude to all the attendees. Thank you.
Thank you. Thanks, everyone. Bye.